Now it's my pleasure, while you're here today, to introduce today's speakers. I won't go through their entire bios because we'll be into next week, but just know they're very smart people, and I'll just abbreviate a little bit. Yuval Marcus, who is a partner in Leeson Ellis. It's a rapidly growing law firm in White Plains that specializes in patent, trademark, and copyright law. Working with a global network of law firms, Leeson Ellis obtains and enforces worldwide intellectual property rights for clients that include local, national, and international companies, from startups to Fortune 500 companies. Yuval is a native of Westchester, grew up in New Rochelle. He's a litigator with more than 18 years of experience in federal courts throughout the country, and he specializes in all types of intellectual property disputes. There's a long list here. I won't read them, but if you really need an attorney, it's clear that he knows a lot about this stuff, so call him up. And I know personally he's very actively involved in the Westchester County business community and is involved in a lot of organizations. He sits on a few, on a nonprofit, Kids Express, which is a wonderful organization. And as I said, I think everyone has a copy of his bio and is more than free to read it. Martin Schwimmer counsels clients, prosecutes U.S. and international trademark and copyright applications. There's a great picture of him here live on CNN on this bio, so it's very impressive. He litigates intellectual property disputes. His clients span from major well-known companies to two guys in a garage. Maybe they were the Apple guys when they started, I don't know. They operate in fields as diverse as consumer electronics, luxury goods, sex-positive products, a real industry term. Maybe he'll talk about that one. Maybe my 50 Shades of Grey comment was right. Entertainment and industrial products. He's best known as a publisher of the Trademark Blog, the world's oldest blog devoted to trademark and copyright law, as well as a Twitter microblog at Trademark Blog. He's well known in domain name circles. He participated in the first reported domain name dispute, MTV versus Curry. Is that Adam Curry? All right, hey, 2 points for me. Active in domain name politics, he was involved in the shouting match in the cafeteria of the University of Santiago, in 1999 that led to the final version of the Uniform Dispute Resolution proceeding. So maybe he'll talk about that. He's been involved in trademarking Yabba Dabba Doo. Wow, that's pretty interesting too. A graduate of Harvard University, J.D. Fordham. He has a J.D. from the Fordham School of Law. So let me introduce both Yuval and Marty. Please give them a round of applause.
I want to thank Larry very much. I'd like to thank you for inviting our firm here today. That's the first time anyone's actually read that far in the bio. I kind of made that last stuff up, thinking no one would read it. First off, I want you guys to know that we're down here in 1 Barker, and we need good places for lunch. So if any of you guys could start something, I'm going to Subway 2-3 times a week. In any event, my name is Marty. I will be your server this evening, and we will be talking about IP protection in the food and beverage industry. I'm going to be talking much too fast about complex legal concepts. So you can either just do Twitter right now, or there is printouts of the slides so you can doodle or do things like that. If anyone does not have a copy of the slides, they'll give you something to hold in your hands. No? We're good? Okay, let's see if this works. It does. I will be just sort of doing introductory definitions of intellectual property concepts, and Yuval will have the fun part where he'll talk about disputes. If I were to boil this down into one slide, I would say that intellectual property is about creating lawful barriers to entry. And it is not a precise fit for the food and beverage industry for reasons that we will get into. So that means you kind of have to maximize what is possible. I would, however, like to start off with the cautionary tale. So for example, a lot of you right now, you're going to agree with everything I say, because I say it really quickly and with authority, whether I make it up or not. But you just can't agree with us. You actually have to do the stuff we're telling you. And I'm going to give you a cautionary tale. Oxford University Press Cambridge University Press. They sued a small college that they thought were infringing their copyrights in their books. And they alleged that the college had infringed 102 times, and each time it's eligible for upwards to $150,000 in statutory damages. So this was a $15 million case, not a trivial thing. These are sophisticated companies with good counsel, and then they get into trial, and as is required, they have to say, well, where's your copyright? Did you file for copyright, and did you have rights assigned to you by the authors? And when push came to shove, they were not able to prove ownership of 66 of their 102 copyrights, and therefore were not allowed to collect damages. So the moral is that that which goes without saying often goes without doing. Of course they own the copyright. Of course the authors that they paid had assigned. Of course the web host guy who designed your website intends for you to own the code. Of course the domain name is owned by you. Of course the guy you paid to do your advertising stuff intends to assign these rights. Then when unpleasantness occurs, was there a writing? Was there a contract? Did you file for trademark protection? Did you file for copyright protection? So the other cautionary tale is something, I'm assuming that you guys are basically entrepreneurs, and you have to remember that going into business is much like marriage in the sense that a prenuptial agreement removes much of the uncertainty once unpleasantness arrives. Now, the lawyer is very much like someone who goes up to the young couple in love, and they're in love, and says, well, you know, someday you may hate each other and bitterly fight over everything. Now, we're not a romantic type by our nature, but let me give you another cautionary tale. This was a case I handled where some architects, they had great designs, and they meet a businessman who has contacts, and they say, let's get together and let's form a business. And they are excited by the venture, and they go out and they start making prospects and doing designs and entering competitions. They figured they'll get around to an involved agreement at some later time. Well, it took them a year to get into that, and they realized the process of negotiating the agreement made them sick of each other. But they had been creating intellectual property for a year. There was now a valuable client list. There was a question as to who owned the copyrights. And then the way of splitting this, unmaking the omelet, involved the law of an unincorporated New York partnership, which you don't want to have happen to you. So I guess this is an ad for corporate law, but as you start out in this venture, have an understanding. But you have the guy, here's the skilled chef, and here's the person who has capital, and here's the person who owns a Hobart mixer, and here's the person who has contacts in industry, and they all believe that their contribution is worth about 80 to 85% of the total venture's worth, and they go out and they kind of figure they'll get around to getting this on paper. And then, of course, these things fail, and then it's left to people to, as I said, unmake an omelet. So get that understanding between partners as to ownership in writing sooner rather than later, because intellectual property could be created from day one or even before. Which brings us to our entree, intellectual property protection. So there's a certain problem that besets food and beverage, and I will use as an illustration Chipotle mayonnaise. I was shopping with my son at Stu Leonard's, and he sees Chipotle mayonnaise, and he has adventurous tastes, unlike his brothers who are addicted to chicken nuggets, and he buys the Chipotle mayonnaise, and he enjoys it, and it is now going to be on our list of things to buy. But what happens when a member of the evil condiments cartel goes up to Stu Leonard and says, so what's moving? And they go, well, you know, we can't keep the Chipotle mayonnaise on the shelves. Here are some of the problems that besets all businesses, but particularly hard hit in the food and beverage industry. Ideas are not protectable. So it's not protectable to just combine Chipotle and mayonnaise. Generic terms are not protectable. Anyone can name their product Chipotle mayonnaise. Facts and functionality are not protectable. As Yuval and I will amplify somewhat, you cannot protect a recipe. You cannot protect ideas about combining two other things. So what do you do? As I said, intellectual property is the creation of lawful barriers to entry, because as you go and try to get people to invest in your business, they will say, well, what's to stop the big guys from ripping you off? And we're here to help you rise to that challenge, to begin to answer that. And the answer is you aggressively investigate all of the forms of intellectual property that are available to your specific business. Now, obviously, we're going to have to use lots of different examples. There's different issues in hospitality than there are in food products, but you'll get the general idea. Finally, we get what are these forms of intellectual property? And I'm going to give really quick definitions of patents, trademarks, and copyrights. If I were better at PowerPoint, I would have done this as a Venn diagram and show that these first three topics kind of overlap with each other. And then I'd indicate that sort of by its nature, trade secrets are a form that doesn't necessarily overlap with those first three. All right. Patents. Dry definition. The sole right to make, use, and sell an invention for a set period of time. Invention needs to be novel, needs to be unique, needs to be non-obvious. Now, this is not an illustration from the sex-positive client that Larry referred to. This is a cucumber sandwich. This is a patent. This is I'm going to be depicting some drawings from patents, and this is a design patent where someone came up with look, we didn't say it was a good idea. It just has to be novel, that someone was able to create a sandwich by slicing a cucumber in this ornamental fashion. This is not the flying spaghetti monster. If that is an obscure reference, you can Google it. This is a patent owned by the Smucker's Company. Does anyone want to guess what this is? Crustless peanut butter and jelly sandwich. Okay. This is about 40 years old, this one. This solved a problem, as they say. This is the actual language from the patent. People want to give flavorsome dips at gatherings, but the dipping mechanisms they provide are often brittle. This is a scoop made out of dough with a hollow handle. I mean, these days we just buy those scoop Tostitos. But here is an example how you can patent some configuration of food. Business methods, there are multiple ways in which you could obtain some sort of exclusive method in your business. How to seat people, how to, those little buzzy things that tell you that your table is ready. The ordering process, how to take orders in a smarter, more efficient way. There are a lot of patents about the ideal configuration of a drive-in. And there are a lot of patents that have to do now with transaction processing. There was one that if, for example, your bill came to $18.47, that it would round it up to $20 by giving you a coupon worth $2 and that way it was an even thing. This is, well, we often get asked, can you protect the theme of a restaurant? This is the configuration of what's called a railroad-themed restaurant. Those are tracks that will deliver the food to any particular table. As I noted, a lot of these theories overlap with each other. So themes of a restaurant can be protected, in this case, through a patent, design patent mostly. Copyright in the decorations of the restaurant, and both I and Yuval will be discussing the concept of trade dress, which is one of the most powerful theories for protecting the idea or look and feel of a restaurant. Copyright protects creations of the intellect, such as novels and movies and paintings. In the context of food and beverage, for example, if your commercials kind of look like a foreign independent musical, in other words, it's a Heineken commercial, your commercials can be protected under copyright. The copy on your menu may be protectable. the manuals, the Bibles of your restaurant by which you tell your people how long to dunk the French fries, that can be protected by copyright. 2- and 3-dimensional ornamentation of your restaurant may be protectable by copyright. By the way, we're not going to get into costs or how one goes about obtaining these protections due to the time allotted. We will be happy to talk about these things, especially pricing, later on. I will note that we are 20% lower than any comparable law firm. So some of you are thinking, what do I want with complex railroad tracks and complex ornamentation? People will come to me because I make the best cobbler in this and neighboring counties. People will know my name. Well, the way of protecting your name is trademark. The lengthy definition is that trademark is a symbol, and by symbol it could be a word or a design or a 3-dimensional ornamentation that designates a source of origin. It tells people who you are, and it is very easy to come up with some of the famous trademarks in food and beverage. McDonald's, and their logo is the golden arch, and one of their menu items is the Big Mac. Some of trademarks are not well thought of. For example, we have the Heart Attack Grill actually sued the 2nd Avenue Deli here. Both of them had the double bypass burger. Evolve will be getting more into trade dress, which is a product's design, product packaging, color, or other distinguishing non-functional element. In a restaurant setting, anything that the customer experiences other than food itself. And to demonstrate the power of trade dress, what is this? Okay, someone was able to identify correctly a source of a product merely through this outline of its packaging. How does trade dress get infringed? I'm cheating a little. This is not really the example of a court case. The drawing on the right is a cover of a book that's out. It was in the news because Jack Daniels actually did contact them. But this shows you how someone can refer to you without using any of your words or descriptors. You can go too far on this. These are dipping dots. This was held to not be protectable because, as I said before, you cannot protect that which is functional. If anyone were to flash freeze ice cream in virtually any way, this is the way it would look. Therefore, the appearance was not protectable trade dress. If you found yourself in a restaurant and the server was wearing orange hot pants and a tight white t-shirt, you would find yourself in some people who, they weren't proud of themselves, but they did know that that's the Hooters trade dress. Signage can be protectable, the exterior shape of a restaurant and the decor. I like this particular exterior shape. This is the Tail O Pup hot dog stand, mostly in Los Angeles. Yuval will get more into fights involving trade dress. I think that I'm running short on time, so I can't really get into the one thing to remember about IP protection with regard to social media. Contact me later. I'd now like to introduce my partner, Yuval Marcus. Thank you.
Good afternoon. My name is Yuval Marcus, and as Marty ably introduced this topic, there are some obstacles that face the food and beverage industry, in particular with respect to protection of intellectual property. And as Marty mentioned, one of the biggest issues is how do you protect a concept? And the answer is it's very difficult. And one example of this is Häagen-Dazs. Häagen-Dazs is basically a Scandinavian marketing theme for ice cream. So it's just an idea. The idea and the concept is we're going to take ice cream and we're going to create a theme related to a Scandinavian country. And then we're going to sell it, and people will buy it because they think that that is something chic or different. What happened was another company decided, oh, that's a great concept. Let's do that too. And they created the ice cream Frusenglaze. And the Häagen-Dazs people weren't too happy about this. And so what they did was they sued the Frusenglage people. And they said, we own that theme. We're the ones who came up with the idea of a Scandinavian marketing theme for ice cream. And you can't do that too. The problem is that concept is not protectable. And so they lost that case. Another example is recipes. Marty mentioned this as well. Now, Marty said that recipes can't be protected, and I think what he meant by that was they can't be protected by copyright. The recipes may be protected under certain circumstances under what's called trade secrets. But the problem with a trade secret is that a trade secret has to be a secret. If it's disclosed publicly, you lose all your protection. So this is a situation, what happened recently in April, is the Fresh Bakery Cafe in Evanston, Illinois, had a chef who basically left the company. And the chef, while she was working there, basically created a binder of all the recipes that she used while she was making products for this company, for this bakery. And including one of the signature products, which had won some awards, called the Cinnamon Bomb, which is just depicted here. And the company, after she left with the binder with all these recipes in it, sued her. And the problem is they couldn't sue her for copyright protection because copyrights do not protect a list of ingredients, or as otherwise known as a recipe. But the theory that they wanted to sue her on was that this recipe was proprietary to the bakery and that it was a trade secret. The problem with that is that after she was sued, the chef gave an interview to a newspaper and said that basically that she had found this recipe in a publicly available cookbook. Therefore, it was not a trade secret. And as you might suspect, what happened next was the case rapidly settled thereafter. So we're going to talk about, we talked about a little bit what you can't do to protect food and beverage company rights, but there are some things that you can do. And the three things that I'm going to talk about are branding, creating strong brands and trademark protection, the look and feel trade dress, which Marty also mentioned, and the secret sauce, trade secrets. I'm going to focus primarily on the second one, but I want to go through all three with you. So brands, we all know what they are, and in the food industry, there are many of them. And as Marty said, what a brand is, at the end of the day, is a source identifier. You see something, and it can be a word, it can be a logo, it can be a smell, it can be a color, and you see that thing, and you think that the product or service comes from a particular source, one source. And that's what the function of a trademark is. And there are ways for you to create strong trademark rights. And no, not every trademark is equal to another. In fact, unfortunately, many companies that are trying to create trademark rights or launching new businesses often do the worst thing they could do from a trademark perspective. And that is choose a descriptive name. Descriptive names are the weakest of all trademarks. Actually, the weakest, you can't get any trademark protection for a generic name. So for example, you can't get protection for the word milk for milk. Descriptive is just one level above that, and you really have very, very weak protection. The best trademarks, and there are a lot of good trademarks illustrated on this slide, are ones that are arbitrary, coin names, or fanciful, or suggestive is one level lower than that, but above descriptive. So there's a lot of different names to choose from. If you're choosing to launch a new product or a new business, you want to avoid descriptive names. And the other thing you want to do is you want to make sure before you adopt a new name or new trademark for your services or for your goods that you do a clearance search. Because you'll learn, what we'll see in this next cautionary tale, is that when you don't do a proper clearance search, you leave yourself to the vagaries of some company out there that may have prior rights who can put you out of business often years after you launched your business. So what happened here was in 2005, a bakery opened up in Beverly Hills, California, using the name Sprinkles Cupcakes. And what they did was, properly, is shortly after they opened, they filed trademark applications for their name, for Sprinkles Cupcakes, as well as for a logo. And they also filed a separate application for the word sprinkles. What happened was they then, as is the, I guess the goal of most companies, is they started to expand. and what they seem to be able to get onto national TV shows like Oprah and the Today Show. They were in national print publications, and they started opening up new bakeries in different parts of the country. So what happened was there was a company in Connecticut, and I don't know for sure that they didn't do a proper clearance search, and I don't know if they necessarily, whether they found the Sprinkles Cupcakes company in Beverly Hills, California, and thought, oh, they're in California, we're in Connecticut, what's the difference? But they opened up a bakery under the name Pink Sprinkles in Fairfield, Connecticut, and this was in 2009. And what happened was in 2011, Sprinkles of Beverly Hills and of other locations throughout the country, and now with a national reputation, learned that there was a Pink Sprinkles bakery located in Fairfield, Connecticut. They weren't too happy about it. So what they did was they sued them in district court in Connecticut. So the question is, why is a Beverly Hills-based bakery with no presence in Connecticut able to force a Connecticut bakery to change its name? As you see, the result of this was that the Pink Sprinkles Connecticut bakery changed its name to Pink Cupcake Shack, using the same logo, but they had to change their name. And the answer is that the Sprinkles company in California did all the things that they should have done, and they were able to create strong rights. And as Marty put it, strong IP rights create barriers to entry. And so now they've been able to stop this company from using a similar name in Connecticut, even though they don't have a bakery opened in Connecticut. But there are a number of different things that enable them to get into that position. They filed their trademark applications, as I mentioned, which issued to registrations. They appeared on national shows, so they got a national reputation. They had expanded, and they had plans to expand into further cities, though none of them were in Connecticut, interestingly enough. Their website allowed you to purchase their products. They also sold their products in Williams-Sonoma stores throughout the country. So based on all of these things, they were in a position to be able to prove, as you have to in a trademark infringement case, that consumers in Connecticut who saw the Pink Sprinkles bakery were likely to be confused and think that there was some connection or that their products were a part of the Beverly Hills Sprinkles Cupcakes establishment. Now, I'm going to talk a little bit about trade dress. Now, trade dress, as Marty said, helps protect the look and feel of a place of business, of a product, or of packaging. And over the years, trade dress has been upheld in certain cases, and in certain cases not upheld. It's important to understand that what trade dress is really a subset of trademark rights. So what we're doing here is, instead of having the name of the product act as a source identifier, here it's the look and feel, or even the shape of the product or its packaging acts as a source identifier. So when you see it, you think that that product came from a particular source. So in this case, the first example I have here's the goldfish-shaped crackers of Pepperidge Farm. They're orange cheese crackers, and they're shaped like a fish. What happened was Nabisco decided to launch a similar shaped cheese cracker. Also, it was part of it was an ancillary product to a television show, which was called Cat Dog. So there was actually cat-shaped, dog-shaped, and fish-shaped crackers in their product. But the goldfish crackers that were put out by Nabisco looked very similar to the Pepperidge Farm ones, tasted the same, were orange, the same color. And as a result, the court determined that Nabisco's crackers infringed upon Pepperidge Farm's rights and issued an injunction against them using that shaped product. In this case, another case involving fish-shaped products, the opposite result ensued. And the reason for that is, in order for you to have trade dress rights, there are really three requirements. Your trade dress has to be distinctive, and that could be either inherently distinctive or it can be distinctive through what's called secondary meaning, acquired distinctiveness. Second, it cannot be functional, because you can't take away the function from the public to be able to create to have exclusive rights in one company by virtue of a particular product being functional. And the last thing is, there has to be a likelihood of confusion. In this case, the Swedish Fish lost because there was evidence that there were lots of other companies producing fish-shaped candy products, and therefore they weren't able to show that it was distinctive. So they lost this case against another company. Here, again, Marty showed the outline of the Coca-Cola bottle. That's been held to be protectable trade dress. The shape of the Perrier bottle, Jack Daniel's bottle, Aquapod, all of these are actually registered trademarks for the configuration of the bottles. Again, in Campbell Soup, they have a distinctive red and white labeling for their cans. Again, when you see the red and white labeling, you think of one company, so that acts as protectable trade dress. Here's another example where if you looked at any of the actual elements, you couldn't get trademark protection for smoked sweets or for hot sausage beef. But what they had was a color-coded packaging for different flavors of their meat products. And the company on the right copied the exact names, the generic names, in the same color. They also had ovals. And then the background color for each of the different flavors was the same as the company on the left. And the court held that that was protectable trade dress, which was infringed by the packaging. So you can have a trade dress in a combination of elements. Again, also places of business, restaurants can be protected. The theme, this was a Mexican-themed restaurant, 2 Pesos versus Taco Cabana. And here's some images of the restaurants, and you can see how similar they are in the way they look. And in addition, the themes of the 2 restaurants were very similar as well. And another example is, you see the blue roof, the A-shaped blue roof anywhere in the country. And before you even see the IHOP sign, that that's an IHOP. And that's because the actual color of the roof and the shape of the roof is acting as a source identifier. A couple of recent cases involving the look and feel of products and packaging. In this case, Maker's Mark made bourbon with a dripping red wax seal at the top. And Casa Cuervo decided to launch a tequila product that had a similar type of cap. So Maker's Mark sued them based on the fact that they had been using this dripping wax seal on their bottles since the 1950s. They actually had a trademark registration for it. And they basically were saying that the introduction of this competing label would cause confusion in the marketplace. So they went into court. They got a preliminary injunction. The court agreed that they had protectable trade dress in the dripping wax seal. And then the Casa Cuervo appealed it to the United States Court of Appeals for the Sixth Circuit. And very recently, the Sixth Circuit upheld the injunction. The argument that was made by Casa Cuervo was that it was aesthetically functional and therefore it wasn't entitled to trade dress protection. But the court rejected that argument and said that basically the use of this dripping wax seal was likely to cause confusion, and therefore they found trademark infringement. Another recent example, and Marty mentioned Scoops. Here they are. So on the left, you have the Scoops product of Frito-Lay. And then on the right, Ralcorp has a product that somewhat looks like a scoop, maybe. And Frito-Lay has sued them, claiming that the products on the right infringe the products on the left. And interestingly, so here I have a question. Raise your hand if you think that Frito-Lay is going to succeed in this lawsuit. I got a couple. The defenses that Ralcorp has raised, and this case is pending now, and there's also patent infringement claims in this case as well. There are 2 defenses that they've raised with respect to the trade dress element. One is they've argued that it's functional because the scoop shape allows you to scoop up dips. I think that's probably a winner. The second argument they make is that the actual chips that they're making aren't in the same shape as what they've registered, which is shown on the left, and that therefore they've abandoned their trade dress because they're not using it in the way that they've registered it. One last example on the trade dress. So we're all familiar with this. This is Reese's Peanut Butter Cups, right? It comes in an orange packaging. Problem is that Mars decided to launch a Dove bar, also a peanut butter chocolate candy, and they used orange packaging. So Hershey sued them. What happened? Basically, what happened is the case settled, and Dove decided to move the Mars decided to change its packaging to remove the orange element. Whether Hershey's owns the color orange for peanut butter chocolate candies remains to be seen. And I'll talk quickly about trade secrets because we talked about it a little bit. The classic example of a trade secret is the Coca-Cola formula. It's been a trade secret now for a very, very long time. And the key to having a trade secret is you have to have something of commercial value, and you have to keep it a secret. Once it gets out, it's no longer a trade secret. Another example of it is the recipe and the way of making Thomas's English muffins to create those nooks and crannies that they talk about. And actually, one of the things that is important when, and I'll talk about a little bit about, this is a trade secret case, but one of the things that's important when you're talking about creating trade dress rights is if you have a particular feature of your product that you want consumers to associate with you, you should be doing advertising that says, look for this particular feature. It's called look for advertising. And that's one of the ways to create strong trade dress rights. Thomas's actually does a very good job with this because you always talk about the nooks and crannies. But the method of doing this is apparently known only by 7 people within the company. And what's interesting about this is that one of those 7 people tried to get a job at Hostess Brands. And there was some interesting, they did a little bit of forensic computer investigation and found that certain files relating to how you make these nooks and crannies had been downloaded at or about the time that they gave notice, but after he'd accepted his offer at Hostess Brands. And basically, Thomas has got a injunction preventing him from being able to accept employment at Hostess because there was a fear that he might disclose the company's trade secret, which was only known by a handful of people and which the company had taken great steps to protect against public disclosure. So here are a few practice tips. Before launching a new brand, conduct a trademark clearance search. Second, avoid using descriptive names as product or company names. File trademark applications for important brand names. Keep proprietary recipes and formulas under strict confidentiality protections, and you should have agreements with employees and third parties that prohibit the disclosure. You should clearly mark anything that you view as to be a trade secret as confidential. And to create trade dress rights, use look for advertising for the look and feel of products, packaging, or places of business. Thank you very much.